just want to say thank you to Judge Waits for your presentation and further reminder of why are we here, and the fact that that's the reason I'm here is to serve and to help others where I can. That's the reason I went to law school, and that's the reason why I love this work. And I think that this is probably largely representative of our next speaker for Joe Hardgrave. Joe has been working at Montana Legal Services for about 10 years. He has represented clients in tribal courts throughout that time. Joe went to law school in South Florida and came to Montana Legal Services in 2008 as an AmeriCorps Legal Fellow, working on the Indian Wills Project. So he's been doing this for a while. Joe has served as a public defender at Northern Cheyenne and at Crow, and also provides public defense services at Fort Belknap, in the Fort Belknap Tribal Courts, which is a place we both practice in, turns out. Joe also handles civil cases in tribal courts at Fort Belknap and at Rocky Point. So I'll go ahead and let Joe lead us through the will process.
Great, thank you, Dave. Is this good? Can everybody hear me?
Yep.
Okay, awesome. So is everyone thoroughly freaked out and weary of drafting these wills now? If so, that's fine. And I consider it my job and my segment of this presentation to put you at ease and to make you feel comfortable doing these wills, and to make you realize the vast majority of them are very easy and very simple. And I don't spend all day, every day thumbing through APRA to figure out how to do these wills. A little bit about my background, so you know why the white guy is teaching this section of the will, and our history of doing wills at Legal Services, to give you an idea of why, the need that is out there and that has always been out there in my 10 years of doing this. So as Dave mentioned, I started my career with MLSA as an AmeriCorps Legal Fellow with the Indian Wills Project, which we had for a couple of years. And it was awesome. It was created as a result of APRA, and our organization realized that there was a need for these wills because of APRA and because no one knew how to do them, and people were afraid to learn how to do them, and they viewed the law as complicated, and other various reasons. Here in Montana, a lot of the tribal communities are in remote areas where there are not a lot of attorneys. And even if there are attorneys close by, they charge a lot of money to travel to the reservation and to do these wills. But from my legal aid perspective, out of all the wills that I've done now over this past decade, we are there to serve low-income clients for free. So the wills that I have typically do, the people don't have large estates, but they do have trust interests. And so they are not long, complicated. I do not consider, this is one disclaimer I will make, I do not consider myself an expert estate planner, but I do know a lot about trust land. I know about APRA. I have done a lot of these wills. And I've done my share of BIA and tribal court probates. And over the years, it was unfortunate that the AmeriCorps Fellowship ended after a couple of years. But for that first year and a half of my career, mainly what I did was I drove around to all the reservations in the state on sort of a regular circuit, and drafted as many of these wills as I could. And in order to address the issue of the vast need for these wills, I also started teaching CLEs right out of school 10 years ago. I first targeted towns close to reservations, I remember one of my first cleas was, well, I did one at Wolf Point about 10 years ago, and I had about 3 lawyers show up. And you know, I had hours of information to give them to see if they would start doing them. But still, to this day, I mean, you know, I am honored and humbled every time I get to teach on this topic, and I view it as addressing the need for more people out there to know how to do these and to be willing to do these, because the need, from my 10-year perspective now, is always going to be there. And we have always done wills and continue to do wills at MLSA. We've gone through various phases of funding. A couple of years ago, we were funded by the we had a grant from the Indian Land Tenure Foundation, which helped us do some of these wills, and that was a good partnership. It was very interesting because the ILTF's mission statement was keep Indian lands in Indian hands, and their mission, that was their mission. And a lot of folks approach the topic of Indian wills as a way to address fractionation. And that was ILTF's perspective and a lot of folks' perspective. But from a practitioner who is out there actually writing these wills for folks, the people themselves are often less concerned about fractionation and more concerned about just being fair to their family or to their beneficiaries. And so you have kind of this push and pull of, you know, you try to counsel the client about what fractionation is and about how small their interests are and the best ways to keep them together. But like a saying in my practice is the client is ultimately the boss. And often they choose a method that's going to fractionate it even further. But hey, that's fine. That's what the client wants. After we lost the ILTF funding, I sat down with our director and we were deciding, are we going to still do these wills? And the answer is absolutely. We feel it is very important. It is a priority to us at MLSA. And as far as I can tell, we will always do these wills. And so that's why I'm here teaching this section, is I have done a lot of these wills and I will continue to do them, and I enjoy doing them. They're relatively easy and simple, and rewarding, and it's much more enjoyable and less stressful than litigation, which is what I commonly do on a day-to-day basis. And the past few years, like Dave mentioned, most of my caseload, I have a full caseload at Fort Belknap, and then some cases at Rocky Boys. We recently lost some staff, so I took over some cases at Crow and Cheyenne. I have some tribal appeals going, and currently I have my first federal case, which deals with Crow sovereignty and jurisdiction over Bighorn Electric Power Company, which is what we would call an impact case, and hopefully, we believe it may go to the Ninth Circuit, but we are very pro-sovereign, you know, by policy, our Indian practice group at MLSA. But that's why I am doing this section. I love this. This is new. My Justice for Montana member found this, and we've already heard a little bit about the Dawes Act, but that's what started this whole. That's why we're here today. That's what started allotments and began this process of fractionation. This quote is great to me. One of the purposes of the Dawes Act Indians civilized once they wear civilized clothes, cultivate the ground, live in houses, ride in Studebaker wagons, send children to school, drink whiskey, and own property. So that gives you some insight into what the feds were thinking back then. But this is what started it all. This is when the federal government started handing out these trust allotments. And so, of course, there was a major loss of land. We've been hearing about fractionation all day. We started hearing it, we've heard some about Cobell. And some of the ladies over here were mentioning whereabouts unknown. We did a project months ago because there was a deadline coming up to find the whereabouts unknown for Cobell settlement money. And there were a huge number of folks in the state that had money coming to them. And just on the side, we took it upon ourselves to do a project to get the word out, and I think it was fairly successful. It seems to me. So, just a little bit more about fractionation. Out of all the wills that we've done, the vast majority of clients that I've worked with, they have very fractionated interests. And oftentimes I'll see, I heard someone mention ITI reports being 30 pages long. I've seen them up to 60, 70 pages long sometimes. But then a lot of those interests, the person may have 0.001% undivided interest of the allotment. And this is very important part of the process of helping your client to plan for their estate is up front, educate them on what they have and what their options are for what to do with it. To discuss undivided interest a little bit more, we heard a great explanation from some of the OST officers over here, and the hand full of dirt analogy. But you know, when I came out of law school, I didn't learn. I had no idea. Well, I had never heard of APRA for one thing, but they didn't teach us about an undivided interest, and it was hard for me, even after graduating law school, to grasp that idea, because I think it's just sort of against human nature, and they always do want to put it in acreage, and often, and very often, the client does not understand what undivided interest means. And so that's one of the first parts of the process, is trying to get your client to understand what that means. And I like to do my analogies to clients, usually in like numbers or percentages. And I will say, you know, say that it's a 100-acre allotment and you own 10% of that 100 acres, the person wants to think they have 10 acres. And they will come in, sometimes adamant that they have 10 acres. And to the point where they want to partition it off, give that certain 10 acres to, you know, a certain beneficiary. And you have to explain to them that, no, that's not how an undivided interest works. You own 10% of the whole 100 acres. And you just have to make sure that your client is informed about that so that they can then make a good decision about what they want to do in their will. This is another slide about, we've already seen some slides about fractionation, why it's occurred. And this is just sort of a graph that sort of shows it in a graph form. So, APRA. I'm not going to talk a whole lot about APRA, but just a little bit, because we've already heard a lot about it. But I think it's important to understand what Congress's intent was, so that you then better understand APRA. And Congress's intent was to address this issue of fractionation. That is the point of APRA, and that's why many of the provisions in APRA, some of which seem harsh or unusual, are there. And you need to know a little bit of the intestacy rules just so you can advise your client, what would happen if they don't have a will. So like the judge was saying, in the grand scheme of things, APRA is still a relatively new law. And you heard the judge say there's still I think there's a lot of things that still need to be litigated. There's a lot of regulations that still need to be enacted. But that's not to say that should make you any more weary about doing a will. But people now have heard a lot of these things, but a lot of people have heard things and they sort of have a misconception about them. But folks have heard of the single heir rule, and they will come to you for a will because they will say, I've heard if I don't do a will, everything's going to go to my oldest child. Well, somewhat true, and then you can explain to them that not necessarily. We need to see, it depends on how much you own, and you learned about the 5% rule, and now you understand that was in order to address fractionation. In my own personal opinion, it is a pretty harsh rule, but I see the point of it. But that's, going down to this last point on the slide. APRA is considered a will-friendly law. APRA and Congress wants natives to write wills, and they and ultimately do not want these harsh rules to kick in. But the judge also hit on this joint tenancy assumption, and it's funny because when I first learned about this, I would tell you, by and large, writing a will is sort of more of an art than a science, and there is no perfect language or exact language you need to use in a will, other than for this, because if you get this wrong, then it's going to put Judge Waits and other BIA judges in a tough spot, and he is correct. And it was funny to me that he mentioned he's seen a lot of folks in Oklahoma write share and share alike, because originally I'm from Arkansas and we make fun of people from Oklahoma. But when I first saw this, I thought any lawyer worth their salt is going to write this. They're going to write out the whole phrase, joint tenancy with right of survivorship. And that's what you have to do, or you have to write tenancy in common. But I have seen a lot of old wills too that say share and share alike, and I've wondered, what does that mean? It seems vague, and I've seen a lot of bad wills out there that people have actually charged a lot of money to write. But ultimately, the point here is APRA wants you and Congress wants you to write wills. So that's what you're going to do, and you're going to do it with confidence, and you're going to help a lot of people by doing it. So it's been touched on a little bit about. So now we're going to go straight into, intestacy rules aside. What are the testacy rules? The rules about writing a will. And those rules in APRA, it's a relatively short section of APRA. APRA is a long law altogether, and there are some very complicated sections in it. Near the end of it are some pilot projects that have been mentioned, but the actual rules for what is a valid will and who can inherit trust land are relatively simple. And the reason I said at the beginning, at the introduction, that most wills are pretty simple, that we don't have to look at APRA for, is the vast majority of people that come in wanting a will want to give their trust property to their children or their grandchildren or both. Well, I like to say, and this has been mentioned, you know, what is an Indian depends on who you ask or what federal law you're looking at. But APRA, in my opinion, has the most expansive, most broad definition of who is Indian under any other law to date. And this is part of the reason, because it says that, you know, a lineal descendant is considered Indian and can inherit trust land, and it will stay in trust. So that's the vast majority of people that come in and do wills. We are not sitting around all day trying to figure out APRA to get these wills done. You know, depending on how the person wants to devise their property, I mean, it's a wide range, but the most simple wills, you know, someone comes in and says, I want to give everything to this one person. Well, we can maybe do that will in 30 minutes and have it done. And a lot of what I'm going to present to you today, there is a huge gap between what makes a will legally valid, and work, and what is best practice. And we try to use a best practices approach, but you know, for it to actually just be legal, you heard Judge Waits's example of the writing on the fish camp wall. You know, you could write a will on a napkin and just have it say, you know, everything I own is going to this one person, and you're 18 or older, competent, have the 2 disinterested witnesses and the date, and it's a valid will. And not only is it a valid will, but it is a very good will in the fact that it is simple and clear. And that is a point that I will be driving home to you during my presentation, that one of the most important things about will drafting is that the will is simply clear to the person reading it what it is that person wants to happen with their property. That's the most important thing. I think, you know, in the field of estate planning, especially, folks use a lot of legalese, and there are a lot of really wordy wills out there, and those, in my opinion, are not the best wills. The best wills are the most simple, most clear wills. You know, one of the only instances where it can get a little bit complicated, but is a fairly common situation, is where the person coming in has a non-Indian spouse, and they want that spouse to inherit some trust land. The simple solution to that is a life estate. The trick to that is as you should know about life estates, you have to have a remainder person that takes the estate when the life estate holder passes. So the remainder person has to fit within that definition of Indian under APRA, and then the property stays in trust. So problem solved. The non-Indian gets the property for their lifetime, and then it goes automatically to that remainder person that is considered Indian under APRA.
Question.
Yes, sir.
Does remarriage terminate the life estate?
Remarriage.
If no, like if the surviving spouse remarries, they still have a life estate even though they remarried.
Okay, yeah, right. And part of our best practice is that we try to write and draft our wills in such a way that the person will not have to come back frequently to change their will. Although sometimes, you know, circumstances will mandate that they will have to do that. But I will get into various sections that we commonly use in our wills so as to accommodate and people don't have to come in and just constantly, you know, update their will, because when a person, you know, updates their will, you have to go through all the same formalities to redo the will. Some people do codicils. We don't do codicils by policy. We just do a whole new will. And every time a person does a will, it's that last, most recent will automatically trumps any of the older wills that they may have. And that's a common situation too, because as you heard, I mean, the BIA, and this is another reason why we feel it's important for us to do wills and to teach other lawyers how to do wills, is that the BIA was doing wills for a long time and then just suddenly stopped. They suddenly stopped drafting wills and storing wills. But a lot of folks will come to you and have an old BIA will, say, in the vault at Blackfeet. But when you do that new will for them, it trumps that old will that's just going to continue collecting dust in the Blackfeet vault. But so, and let me back up here a minute. The wills that we write, we include the entire estate, and as you know now, it will be probated if they have trust interest. It will be probated by the BIA, but it will also be probated at the tribal court. And in rare instances, there could be a third state probate if they actually own property off the reservation, real property, that sort of thing. I've rarely ever seen that. But when folks come in and you are initially advising them on the options they have and what they can do with their estate, this is what you're dealing with to address fractionation. These are the tools. And like the OST officer was saying, when they come in with their ITI report, and they have a ton of interests, we like to tell them the best way to keep the interest together is to give one interest to one person. And so, like they were saying, if they come in to us with an ITI report with the beneficiary's name written on each interest, oh, we're moving ahead quickly. But if they come in with that ITI report and have no idea what they own or where it's at, or that sort of thing, it's going to take a little bit longer, and we're going to have to send them back to the BIA where they do have maps and can show them where their land is at. But obviously, this is the best way to keep a trust interest together, is to give one interest to one person. Why people commonly don't do that is because a lot of folks just want to be fair. And they'll say, you know, I just want everything to go to all my children in equal shares so that no one gets upset. And that's what leads you down to, okay, we're going to end up fractionating this even more, because that's the most fair way to do it. When you're giving one person one interest, it's usually mathematically and practically impossible to make that perfectly equal amongst each beneficiary. So it's not totally fair, it's not totally equal. But another thing to consider here, and another common situation, is that folks will come in and say, I want my trust land to stay in my family forever. I think I had someone last week tell me that, say that. Happens all the time, and it's understandable. And that's when you have to have the talk with them that, no, you cannot do that. The law does not allow you to do that. The law, it's called dead hand control. The law looks disfavorably upon that. And what I like to do to get people to understand it better, and so they're less upset about not being able to do that, is I first explain to them, when you're a property owner, you have rights. You have rights as a property owner. You can do all these things with your property. But when you decide to pass that on to another person, they then become the property owner and they have those rights. So that is one reason why you cannot dictate from the grave that the land is going to stay in your family forever. And they want to do all sorts of other unenforceable things as well that I'll talk about briefly. But these are some ways these are some options to at least keep the land in the family for a little while. So, you know, a joint tenancy with right of survivorship has already been explained a little bit. Someone mentioned it's the last man standing rule, and that's how I like to describe it. And then I give the example. I say, you know, if you have 3 children and you're giving your interest to these 3 children as joint tenants with right of survivorship, they have all the rights of a property owner. They can possess it. They reap the benefits, the income that it's producing. But they cannot sell it or give it away because there is a right of survivorship. Whoever is the last survivor out of the 3, all the interests come together. When that first child passes away that you give the land to, their interest automatically goes to the remaining 2. So that someday down the line, all the interests come together when there is one person left. But then, when that one person is left, then they can do what they want with it. They can sell it, gift deed it, what have you. And then life estates, we've discussed. But as I've mentioned, in my experience, most people prefer tenancy in common when they're giving trust land to multiple people, which fractionates it even more. Yes, ma'am.
And how do you, because I understand all of that, how do you, because most people do want it to go so that it passes down to every child's heirs, basically, with the tenants in common. So I get that, but how do you get them to not, I mean, obviously you can't sway them and make them do one thing or another, but they're gonna want to always go tenants in common because they feel like they're shorting the grandchildren of their children, because it's going to go to the one surviving child, and then those other children of the grandchildren are getting left out eventually. So how do you, yeah, that's what's going to happen. I mean, how do you tell them that?
Yeah,
That's exactly what's going to happen.
That's what I'm telling you. That's what happens most of the time in my experience. And that's why it's at one point we had someone I was supervising who was did the Wills Fellowship after I did, and come to find out that person was very zealous about addressing the issue of fractionation. And come to find out that person was a little too pushy, I think, on clients. I mean, us lawyers, we talk about client control. I'm not the best at it because I can be somewhat of a pushover, and I say the client's the boss, right? But others are much more forceful than I am with their clients, and I believe this particular staff person was. We found out later on.
Yeah.
But what are you going to do? I mean, and I try to not make much commentary on APRA as a whole, like, is it going to work or not, or you know, my personal opinion of it. But you know, I see the point in it, and fractionation is a serious problem.
Right.
But I think this is always going to be an issue. You know, Congress, I suppose, was doing their best in trying to address the issue that they created,
Yeah.
essentially, and hopefully it will have some effect on fractionation as a whole, big picture wise. But this is what most people are going to want to do.
Yeah, and that's
Yeah.
what I found. I did have one situation where the one lady was saying, okay, I'm going to give this fraction to this child, this fraction to this child. And it was like forever, because then she was trying to, okay, that fraction was pretty small. So I had to give her another section here, and I mean, I thought we were gonna be there forever. I think Suzanne's ran into that too.
At those clinics I've had, and I would say mild to moderate success, talking about equitable rather than equal,
Ah, yeah.
okay? You have 3 children. If you do the tenants in common thing, you know, it's gonna be divided up and their fractional interest is gonna be point whatever it is. Do you have other assets? Is there something else you might pass on to your children that would be equitable? And I've had some success with that if there is, you know, something else that they feel is as valuable.
Oh, I like that. That's very creative. That's a good idea. And another point here about, as we're talking, you know, this is the beginning of the process when you are advising the clients, you know, what their options are. But for us lawyers who are used to strict rules of confidentiality and all our rules of ethics, I find when I'm on reservations and folks are coming in to talk about doing a will, they will often walk into the room, sometimes with their entire family, and they want everyone to hear what you have to say, and they sometimes want to make a decision as a group. And this freaks out people with state licenses, right? But it's kind of a cultural thing, and I think it's cool. You know, and in a way, I mean, if you explain to them that, hey, and another common situation is it's a family member that initially gives you the call, not the person who the will's for. It's that person's child or that person's whatever, and you have to explain, well, I'm glad you're calling. But we need to ultimately talk to your mother because it's going to be her will, right? But you know, you just have to be careful and explain, you know, to the person who the will is for that, hey, this is confidential and we have a confidential relationship here. But if you're bringing your family in here, you are waiving that confidentiality to your family. And so it gets very sticky for folks who are not used to that, but I find that's a very common situation. Okay, we've gotten through that. Okay, so I'm glad that Carrie passed out her example of an ITI report. We typically require a person to come in with their ITI report for a couple of different reasons. And you can get an ITI report for a client, but the BIA is pretty strict about you will have to get an authorization release of information in order to get it. But so it's much easier, we think, for the client themselves if they just walk into their local BIA office. They will print it off within a couple of minutes, and then they will have their ITI report. But some of the reasons why we feel it's essential and why we want an ITI report is because often the person doesn't know what they have. And when they get that ITI report, they'll see, oh, wow, I didn't know I had this allotment in Oklahoma or wherever. So that's one important reason to get an ITI report, is so you get a clear idea of what the person actually has. And then you can explain to them and show them what they have. And another reason why it's essential, we have to have an ITI report in order to identify the trust allotments. Now, and that's, here we are talking about best practice versus what would be legally valid. You know, if the person comes in and says, I want everything to go to this one person, you don't necessarily have to list out identify every allotment. It would be best practice to, and people like Judge Waits would appreciate that better. You know, if they're going to do any of those other options where they give one interest to one person or whatever, you've got to have that to identify the trust allotment. And then, you know, you can help explain to them what they actually own, like the percentage, how small the percentage is. So we have a ton of slides here on ITI reports that you probably can't see from where you're sitting, which is okay because you have an example that Carrie handed out of one. I'll just point out a couple of things. And you know, for us folks that are actually drafting these wills, like they were saying earlier, these numbers here, these are essential. These are what you use to identify the allotment in the will. So this is one of the most important parts of the ITI report for us drafting.
Where are you pointing out? What's the title? Location.
Yeah, the tract ID.
Oh,
So see 204M, it's a mineral,
Right.
and here's a number, and sometimes they even have a suffix. So, you know, you include all that when you're identifying the allotment. And then you come down here, like they've already mentioned, to show them the actual percentage that they own of that interest. And you just move the decimal over a couple of spots, and you can tell them, you know, the percentage. In my experience, most folks have very small percentages at the tribes in this state. But every once in a while, someone comes in who owns a pretty sizable share, or actually owns 100%. Every once in a while. And then you're like, wow, I don't see this very often. Here, yeah, you own 100.
Once out of 30.
Yeah. So see, we have a ton of slides that go through. So if you're interested and it took me a little bit of time to get good at reading ITI reports, only because when you get a whole report printed off, sometimes it's kind of weird, and where it cuts off and starts a new interest, and you have to get kind of used to that. But then after a little while, you get pretty comfortable with them. Legal description, you do not write the legal description in the will. All you need is the allotment number. You would write a legal description if the person owns fee land, then yes, then you need to write a legal description. But on a trust allotment, you just need to use those trust allotment numbers to identify it. So see, here's an example of how we would write in the will, identify this a particular allotment. Or at least this is how we do it. I've seen it a little bit shorter where they just include numbers. But we feel this is best practices to have it look like this at the top.
Joe, have you gotten feedback from Judge Waits about what he prefers to see in his court?
I have gotten, not from Judge Waits in particular, I have, years ago, I got a lot of feedback from Judge Jim Yellowtail and had some protracted litigation with him over a case where a will was being challenged as being unduly influenced, and actually got him to reverse one of his own opinions. And so we became a little bit closer through that process. That's a great question. I mean, I think various judges are going to differ on exactly,
I would think so.
yeah, on how they would want it. But this, yes, Deb.
I'm just curious if you've ever been tempted. I mean, I've been faced with these ITI reports that are like this, and 15 children, just attaching that, just writing the names of who you want to require that interest, and attaching it to will as like an exhibit or something.
You know, that is an interesting idea, Deb.
I know, I've actually, I was
I
thinking
asked
the
Judge
same
Waits
darn
about
thing
it.
many times.
Yeah.
I've actually thought the same darn thing.
Yeah,
Every time I sit with one of those, I think, isn't there an easier way to just write the name beside it or something?
I would be weary of trying that.
What would be the problem? Can you think of any downside
But
off the top of your head right now?
well, let me tell you this, and thanks for the question, Deb, because my view has always been, and I argued this to Judge Yellowtail, that a probate judge's job is to look for ways to make a will valid, not the other way around. Not look for ways to make a will invalid. And you heard him describe a situation where the notary, they decided to make the notary a decision. That to me is what they're supposed to be doing, looking for ways to make a will valid. So under that idea, it would probably be okay to attach the ITI report.
I mean, I guess there's always risk that you miss a page or there's a question about it or something, but I mean, I know when you're sitting there at those will clinics and there's a number of, even if you just use the allotment number, there's a possibility of fat fingering or,
Exactly.
you know, making a mistake. It just seems like if you're using the official record.
Right,
I
right.
know.
Right. The only downside is, as you've been hearing today, sometimes it takes the Bureau time to get things updated. And whether it's, you know, a probate from another family member that they're going to inherit, or they have already gift deeded something and then you're waiting for that to get into the system. Sometimes an ITI report is not going to be up to date.
So if we don't have that, when we're doing the clinics, for example, that we wouldn't have that current ITI report that we're going off of anyways.
That's the most current thing that you have at the time that we printed. I mean,
Right.
that's the real, I mean, there's no way to do live real time because of the time practice.
Right.
The other, somebody asked about the legal description, and we talked about this at the last CLEAD last year. do not ever put the legal description
Right.
on for Indian country because they may not be accurate. And you could end up undoing what you just tried to do because you included the legal description, that land area code, the prefix, the allotment number, and the suffix is the most important number, because if that legal description changes because they've had a different survey or partition or whatever, that allotment number is still valid, but now that legal description, and you have just either not transferred enough of the property or transferred something that they didn't have. So just stick with the land area code, the prefix, the allotment number, and the suffix. Because we see that a lot. There's always being corrections made to the legal description.
Right, and one way that we try to provide for instances like that is, you know, we feel that our residue or residuary clauses at the end of the will
Yep.
will catch that.
Right.
But let me also mention, you know, we've been talking about gift deeds today and land buyback programs that are currently going on. Clients will often come in and say, well, I'm about to apply for a gift deed on this one allotment, or, you know, the buyback's going to be here next month. And our advice is always go ahead and put it in the will now. And that's what we want to do, because should something happen to you tomorrow before it goes through, then you're covered. But if you put something in the will that when it comes time for probate, the person no longer owns, so what? They just go on to the next item. So we feel that's a best practice too, to cover it all. Yes.
And Joe, just with land buyback being back in this region, when you're talking to somebody and they say, oh no, I sold it all in land buyback, there's one, they're not guaranteed to get an offer. Two, not all of the allotments that they own on that reservation may be included, so they may be under the impression they sold everything because they sold everything that was on that offer set, but they still own land. Still make them come double check and get an ITI report. We've worked with individuals drafting wills where that's what the person said is no, they didn't, they sent it back and they still had a long laundry list of property that, I don't know, they weren't aware of or forgot about or were under impression that they had sold all of it. So just because they said they participated in land buyback, still request them to come back to us to verify, because their ITI report, if they don't have anything any longer, will say there's nothing there. We
Right.
actually print a report and it shows nothing.
Yeah, thank you for that.
It's really important with it coming back over here again, because people are getting confused about what they still own it.
Yeah, and you know, the past few months, a lot of folks at Blackfeet are saying, no, the buyback's going on, and so we keep repeating, you know, like, no, let's go ahead and put this in there. The most important point of my whole presentation. Okay, so I was told you folks don't have this in paper form, but this should be available to you. They give out the template that we typically use.
Joe, I think we actually did get the hard copies have arrived.
Oh, great.
Megan's got them up here.
Great, okay.
Those came during the day. Just to-
Awesome. So your hard copies are here, folks, and you should also, I think, have an electronic copy as well.
Let me see about if I can maybe go grab those for you.
Okay, great.
Yeah.
Thanks, Dave.
One's a little small to look at.
So just to go through briefly,
I got old eyes.
okay, I have plenty of time. Yeah. So at the beginning of the will, and you know, we've gone back and forth over the years about what to say here. What would you ladies in OST suggest that we call this?
That's probably the best, because sometimes they use their enrollment numbers and sometimes they're, depending on where they're enrolled at, might be a BIA identification number. I like that.
Okay, good.
BIA number.
Has an enrollment.
Right.
Right.
Have an N number.
N
Right.
number or an L
Right.
number.
So that would be the best
That's,
definition.
that's actually probably the best.
Okay, great. Yeah, and we originally, so a little over 10 years ago, when we started doing wills at MLSA, we got a lot of our materials and knowledge and information from the folks at Seattle, who at that time were considered the experts on this stuff. And that's where our template originated. So it's an old template, but we still use it. We've kind of pared it down a bit over the years. But so we ask for a BIA identification number. And then here, you need to be very careful about what you write here, because I've had folks just write the name of the reservation. That can be very offensive, and the client, for instance, where I do a lot of my work the past couple years at Fort Belknap, well, there are 2 separate tribes at Fort Belknap. So you can't just write Fort Belknap here. You need to ask them what tribe they are affiliated with and get that right, because you also include that later on, that information on the self-proving affidavit. So we always include a section. I think the law does this anyway, but just to make it clear, every time you do a new will, it revokes any and all older wills. I actually just inherited a case a probate case at Northern Cheyenne from one of our staff members we had to cut, and the person had 3 wills, and Judge Robinson ended up invalidating all 3 of them. And the reason why, and I see why, is because it was interested witnesses that had signed all 3 of them. But yeah, we feel it's important to identify the family up front. And part of the reason is people often want to give property to one child but not another, that sort of thing, disinherit people. And so this makes it clear, this section up front, that that the person didn't just forget that they had this child or whatever. Now some people will come in and they want to disinherit somebody, and they want that language in there. And initially I will tell them it's not necessary as long as your will is clear. What's going to protect you the most is that you have a valid, clear will. But when someone is adamant about it, we will add a little bit of language that I specifically disinherit this person, and then try to leave it at that. Of course, human nature being what it is, the person will then want to tell you for an hour why it is they are disinheriting, even though you don't really care. But the flip side of that is that can be one of the most interesting parts of doing this work, is getting to know some of these folks that you're writing these wills for. And I will never forget, out of however many wills I've done over the years, the oldest person I ever did a will for was 101, and she was in Hayes on Fort Belknap. And I will never forget that. And that was like 8 years ago. But this is why we do an identification of family section. And we have, our form is pretty wieldy because it includes all, every circumstance that Seattle thought that you may encounter. So what you end up doing is deleting most of the will template that we give you. But it should but its purpose is to provide for any circumstance that you would come across. I had a guy a couple of months ago, this is the first time this had ever happened to me. He did not want to say anything about his children in this section of the will. And he was adamant about it. And come to find out, part of the reason is his fear. He thought that he may have some children out there that he didn't know about that were just going to come out when the time came to do his will. But we worked through it and got that will done. Finally got him to admit it.
What if they don't come in with all the tribal ID numbers of their children? Can you do it without that?
Yeah, great question. I mean, this is that difference between is it legally valid or what's the best practice. And so for us, we try, we want that. We want the children's birth dates. We want the children's enrollment numbers. We want all that stuff, but it's not necessary to make it legally valid. So let me talk just briefly about personal representatives. There are a lot of misconceptions out there about what a personal representative is and what they can and cannot do. Other words for it are executor or administrator of the estate. Technically, the person does not have a personal representative in the BIA trust probate because the federal government is their personal representative as owner of the land. But we feel it's very important to have a personal representative, not only because that's a person that can assist in the BIA probate by giving the BIA the original will and such, but it becomes much more important in the tribal court probate. And the misconception out there is that, and I have seen a lot of people fight over who's going to be the personal representative because they believe that if they're the personal representative, they get the estate. And then what you hear from folks is, so-and-so has raided the house and taken all the stuff and they're partying at the house and destroying the house or that sort of thing. Seems to be a common situation. And I just explained to the client that, we can file for an injunction, we can try to keep this from happening, but in the end, the personal rep is not going to own that, and they're going to be beholden to whatever it is they did take when the judge makes a final order distributing the property to who it is really supposed to go to. But that's one misconception that's out there about personal representatives. Here's the meat and heart of the will.
So can we back up, Joe, to the personal representative part? Is that all there is in there now? Because I used a form where it says the will shall be a non-intervention will to the extent of, and it was a form I got from you. Is that not used anymore, or?
Like I said earlier, we have been paring down the language. And I have seen language in personal representative sections that are almost 2 pages long, even longer than, I know what you're talking about. But, ultimately, the authority of the personal representative is going to be partly up to the jurisdiction and their probate code and their judge, what the authority that the personal rep has. But in my experience, the way I like to describe it to clients is the personal rep is kind of a thankless job because they're just doing the work to get to the court what the court needs, And then their job is to, which usually involves an inventory. You know, the judge, the probates I've been doing at Belknap lately, the judge will ask the personal rep to submit an inventory of the estate, and then try to protect the property while it's in probate. So it's kind of a thankless job. But this is going back to my point that, I mean, the shorter the language, the more simple and clear it is, the better in our opinion.
Hey, Joe.
Yes.
You may touch on this or people may know, but on the federal administrative probate side, the BIA essentially stands in the shoes of like a personal representative, or they're the trustee. They're preparing the case, bringing the inventory. So the personal representative and a will in that particular adjudication doesn't have they don't go to Judge Waits and become appointed PR.
Right.
You know, you generally go to tribal court and they will appoint you PR.
Right.
That helps clarify.
Yeah, absolutely, absolutely. So, this is our section, devising the trust interests. This is a long section in the template that we hand out to you because we try to provide for every type of situation. And so you can just read through this in your materials. And use the template as you see best fit, but it will provide, it will give you language for every type of situation. Now let me briefly discuss this. IIM accounts have been discussed at length today, which is very good, but when you are bequeathing money that is in an IIM account in a will, what you are saying is you are designating a person who's going to get the money in that IIM account at the time of death. And so there's a big difference, as you've heard, between the money that is in that account at the time of death, which is often not much with the clients that we deal with. And yeah, you know, there's some leasing that goes on and they might get, you know, a few dollars a year or whatever. But I still tell the client this is very important because it may take a while for this to be probated. And as the years go by, if it's taking time on the BIA end to probate this estate, money may be accruing. And what tends to happen is when it's time for the final distribution of this, there's a lot more money in the IIM account than there was at the time of death. Well, the money that accrues in the IIM account as the probate is pending follows the interest that produced the income. So the person that you are willing the land to, that has the lease, that is bringing in the income, is going to get the income that accrues while the probate is pending. If that makes sense. Yeah.
And that's not an easy concept to explain either.
No. Our clients tend to love this, which is good because it makes your drafting quicker and easier. There's a section in our template that alludes to a separate writing to devise personal property. So you describe to your client what personal property is, which is can be a lot of different things. And you say, because of this section that we have in the will, this allows you to make a list on your own where you just list the item, the piece of property, the person it's going to, sign it and date it at the end, and put it with the will. You don't have to do, and so with this in our template, you explain to the client, they don't have to do a separate list if they don't want to or don't get around to it. But if they don't, then the personal property is going to fall back to the residue clause at the end for personal property. But clients seem to like this because it allows them to update it, you know, as long as they keep signing it and dating it. It's just an easier way to deal with personal property. So we have a section for bequest of non-trust property. So, you know, if a person were to have fee land, this is where it would go, and then you would need a legal description.
And Joe, I've done for fee lands, I've done a beneficiary deed, and they're filing the beneficiary deed, but I make sure and mention it in here also in the same manner with the whole legal description on the property and everything.
Yeah. Yeah, I like that. Yeah. Now, a lot of folks have homes, and let me talk briefly about homes because, but before we get into the residue, because you know, it's already been discussed that homes can be complicated because, and for a long time, right after APRA was passed, I mean, there was mass confusion over whether homes or structures were considered in trust. And that has since been cleared up. They are not in trust. And the BIA is not going to deal with the home, even though they are going to deal possibly with the land that it sits on, because the land that it sits on may be an individual trust allotment. So in practical terms, that can cause problems. But in our experience, you know, homes can be difficult on some of the reservations here in Montana because sometimes it's difficult to get documentation of ownership. Oftentimes there are no deeds. Oftentimes there are no documents that most estate planning attorneys would require you to have to do a will. But then to further complicate things, home site leases have been brought up, and we deal with those commonly. But as it's been said, you don't put leases into wills because leases you don't necessarily own the property. And a home site lease, to explain it to folks that don't know much Indian law, haven't practiced on reservations here, it's fairly common for the tribe itself to have trust property that they then lease to individuals to live on. So that's what a home site lease essentially is. It's tribally owned trust land that a person is leasing to live on. And so what I typically tell folks about those is, and in my experience, is that in order to handle the home site, and sometimes the home site leases are like, you know, 99 years for $5 or something like that. I've seen all kinds of things, but most of the tribes that do these home site leases, you put the successor on a successor form with the tribe for that lease. And as it's been mentioned, the tribe may have its own rules about its own, the trust land that the tribe owns. They may only, allow that to be passed on to another member of that tribe. And so you have to be careful about that, but you usually tell the client, go to the tribe's office to see if they have a successor form for that. Yes?
Are there some instances where the person is buying that lease property or in a contract to buy that lease property? Because I thought I heard where they've called in, and you're shaking your head, yes. I thought I've heard where they've called in and said that they're in the process of buying and the leased property.
Yeah, because you've got tribal home site leases that are on tribal land, but you also have homes that are on allotted. Not all of those have leases, and so that's where you want to see a copy of the lease to make sure they've done the designation. But if they don't have a lease, that's where it's important to tell who the successor is, just because of the fact that on allotted, not tribal, because most of the tribal they make you, but allotted tracts will also have home site leases, and that's important. That's where we talk about they come in to us and we can tell them, and then we can either send them to the tribe for the home site lease or send them to the BIA to get a copy. So they actually have something that shows either they've designated it already or they need to place it in the will.
But you're saying the home site on an allotted land can be purchased? Is that?
Yeah, you can sell a house on allotted land. You can do that.
That's different on the CSKT though. You may
I'm thinking
own the
I've-
structure on leased land on the CSKT, but
I'm thinking I've heard it on the CSKT land that they can be buying some of those leased land.
Okay, remember, think of your house as not attached to the land.
Right,
The land isn't what's sold, they're selling the
Right.
house.
and I get that.
And then the lease then they'll do a transfer of lease and get approval to transfer the ownership of the lease in
Right.
which the land, or the house sits on.
Right,
And it is, I didn't hear Francis mention this today, but we also have Mutual Health HUD Home, and the tribe operates, they manage housing.
oh yeah.
And sometimes they have rules, and so
Right.
you can go through a purchase of your home and potentially of the land. There could be a leasing situation where maybe a descendant is eligible, potentially, or a non-member spouse. I mean, there are different rules. I think, like what Netta's trying to recommend is if you can get the individual to get you as much information as possible, or refer them so that we don't miss something.
Okay.
Confirm back to the tribe. But there are
Okay.
some uniquenesses with each reservation.
and I think that's kind of where my question was coming to, is we may run into a situation where someone says, I'm buying the leased land, not the structure, because they might own that already or something like that, but the leased land, and then that's when we need to come get further information.
Right, and clarify, because it could be something that the tribe owns through HUD. It could be all kinds of things.
Okay.
And the other thing too is certain tribes will have different rules on who can have a home site lease. So like a Northern Cheyenne, only a member can have it. So you want to make sure that they're giving that to an eligible person. And that's why when it's talking about home site leases, where we suggest when they get the ITI report in that, they come talk to us and bring those questions up so that we can make sure when they get to you, they've already got the answers to that.
Okay. Because it's gonna vary based on the tribe, is that correct? Yeah, okay,
Mhm, mhm.
all right.
Yeah, and in our experience, even just dealing with low-income clients, they will often have homes, and so it's very important. And on a lot of the reservations in the state, housing is scarce. It is like a precious commodity, and so it is very important to have that home, properly devised in a will. Absolutely. I've been involved in litigation at Northern Cheyenne pre-2016 probate, where Judge Robinson was the probate rules were unique back then in Northern Cheyenne, in that the probate code allowed for folks to come in an intestacy situation and just give testimony to what the person who had passed away, what their wishes were. And so I had a situation where two brothers came in, and they both said their mother said that they could have the home, and there was no other evidence. And so the judge just had these two competing and appointed us like a special administrator to help him try to figure out the situation. And we tried to come up with some idea, like one could buy out the other, but neither one of them really had any money. And so in the end, Judge Robinson just said, well, I'm gonna give it to both of you brothers, and you're gonna split it, and you're gonna have to get along. That's the only thing we can come up with. But yeah, I have experienced a lot of people fighting over homes lately. So yeah, get it in a will. Get it in a will.
Put the, where you want the home to go to separately if it's not.
There's a section. There's a section in our template for that, which I think I skipped over.
When you talk about, you refer it, and it's like Article 9, I think.
Yeah,
It's
yeah.
similar
It's
to Article 9 because it's dealing with non-trust.
yeah. It's in the template. Absolutely. And then getting to, so we do 2 separate residue clause, or residuary clauses, where we explain to our clients these are very important. I explain them as the safety net for, and going back to the point that you don't want to have to, redo wills constantly for folks. But we separate it out so that we have a residue clause for trust interest, and then we have a residue clause for non-trust property. We have a section to list a guardian. That doesn't come up very often, but it might if the person has a minor, has a child, and they want to designate who's going to care for that child. We have a section for burial. Let me speak briefly about that. We at MLSA have gotten to a point where we do not bring up burial as far as something you put in a will unless the person requests it. But what we do is we counsel the client and say, and the reason why we don't do that is because if the person just puts what their burial wishes in a will, a common problem that we've been experiencing the past few years is people can't, and I'm going to get to that here in a minute, people cannot find the will when it comes time. So if they can't find the will, they're not going to know what the person wants for burial. So we advise our clients to tell their personal rep or their family, somebody they trust, what their wishes are. But we're going to leave it out of the will unless they specifically want us to put it in the will, and then we will. Which leads me to another point I wanted to make, is that folks often want to put things in wills that are not legally enforceable. For instance, going back to the example of, I want the land to stay in my family forever. Or if so-and-so is still married to so-and-so, they're not going to get this or that, or whatever strange conditions they want. And so we just counsel them and say, okay, that is not legally enforceable. So we cannot assure you that that is going to happen. But if you really want us to, we will put that language in the will so that at least it's known what your wishes are, but they're not going to be legally enforceable.
And that's the same for, like, if you want your minor children to be cared for by a certain person, it's not legally binding, but you can put those wishes in. I'm just, you have to have a separate proceeding to decide who's actually going to have custody of your children afterwards if there's not a surviving spouse. So
Right.
we still can put in the will, I'd like John Doe to be the guardian of my children.
Well, yeah, and an excellent point, and you got to remember, and you have your years of experience practicing at Crow and Cheyenne and other places. It's going to be up to the judge. I mean, the code may not even address that. There may not be any law on that in that jurisdiction. But yeah, you're right.
Do you normally put those wishes in the will somewhere?
We kind of push back initially and say it's not legally enforceable, and see how the person reacts. But we say something to the effect of, but if you really want us to, we will put this language in there, just so it's known what your wishes are. Yeah. The invalidity clause. Okay. I'm trying to speed through this. I know I'm running out of time. So at the end of the process, you've got the will drafted. It's time to execute the will. Judging competency can be a very difficult thing. Now under the law, competency to be competent to do a will is the lowest level of competency in the law. And I have done wills for people that are in ICU units, people who are diagnosed with dementia, other things like that, and it's what you're kind of begging for someone to challenge it. But so you need to be extra careful in those situations. But if the person understands what we would call a lucid moment, what they are doing at the time they sign the will, if they understand their property, what they have, and who it's going to, and what they're doing, that they're doing a will, that is about enough to be competent enough to have it be a valid will. But the stickier the situation, the more careful you need to be. You may want to ask them some questions in front of the disinterested witnesses. Like, how old are you? Who's the president of the United States? Do you know what you're doing right now? And just get them to say a few things, just to show that. We've talked about disinterested witnesses, and then we've talked about self-proving affidavits. You don't need one for it to be legally valid, but we feel it's best practice, and our form has a self-proving affidavit in it. Another thing that comes up before I get to storing a will, people are often concerned that it's a common situation that the client comes in and says, I have so-and-so in my family who's a troublemaker, and I know they're going to challenge. They're going to challenge the will. What can I do about that? And I even had someone just a month or two ago, this still comes up, where someone says, I want you to put in there that if so-and-so challenges the will, they only get $1, which I don't know, where that comes from. It sounds like total garbage to me, which is essentially what I tell the client. But I advise them, I say, there's nothing you can do to take away a person's right to challenge that the person doing the will was either incompetent or unduly influenced. You cannot take that person's right away to make that claim. But, and this is what I say to the client, but the people who wrote the law knew that wills would be challenged often, especially the more that is in the estate, the more likely it may be challenged. A will may be challenged, that the burden is on them to prove that, and it is a high burden. And it does throw a wrench in the process, and I've been through it personally in a BIA probate where, a will was challenged by, based on undue influence, which is going back to why you have to be careful when they come in with the family initially, okay? And so what we do to protect from that is when it comes time to execute the will, the family is out of the room, and that gives us an opportunity to say to the client, okay, now is this how you want it? Your daughter's not in the room right now, or whoever gave you a ride here and has been helping you with this process. Are you sure this is how you want it? And so we get that assurance without the family in the room right before we execute, just to protect from that. But now going to this issue, which is a big issue that's coming up with us because over the years we've done so many wills that And the BIA does not store wills anymore. We give the original will to the client. And we just advise them that this is the original, this is the most important. You can and probably should make copies of it, but the one with your ink on it is essentially the only legally valid version of it, except in rare circumstances. And so you need to store it in a safe place, and even just as importantly, you need to let someone you trust know where it's at. Because the problem that we're seeing is we're getting a lot of calls lately from people who cannot find the will. But this is just our policy. We at MLSA, we're a nonprofit, we're pretty poor, we can't afford vaults, we can't afford store wills. Plus it's a liability issue. So we don't know exactly what the solution is. There are varying opinions. As I've taught this CLE, I've started debates amongst the audience whether they should do a safety deposit box or this or that, and different people have different opinions. I'm not sure what the solution is, but just to make you aware that is becoming an issue lately. It's about the storage of the will ultimately. So I'm about to run out of time. Let the client know, you can always revoke or amend a will, but you suggest not to do that unless they have something else in place, but it's as easy as just tearing up the will and saying, I revoke it, it's revoked. But you don't necessarily want to do that unless you have something else in place, is what we advise our clients. And so that's it, and I am right on time. Any questions? Well, it's been a pleasure, and I consider it part of my job to field questions from members of the private bar who want to start doing these wills. And I say this every year, and I don't get many calls. I don't think many folks in the private, or enough folks in the private bar are doing them. But please give me a call. It is my pleasure. I love doing wills. I miss those days, the beginning of my career, when that is essentially all I did was wills. And now I do somewhat complex, crazy litigation in tribal and other courts. But doing wills is fun and easy and rewarding, and a lot of people need them. And there's not enough people out there that know how to do them.
So I'm confused, Joe. I was trained by you. I've taken this training. I've gone to the Indian will clinics every year. Last year I didn't get called once.
But you're confused by what?
Why I didn't get called if there's such a big need?
Well, the people in the private bar
Who
not.
does that? I mean, was it AAA Legal Services and they're not doing it? Or they have Indian will clinics all over the states that I went to.
Yeah, over the past couple of years, the Triple Legal A had been doing clinics. I don't know what their schedule is in the future. We at MLSA, we don't do clinics, but we do as many individual wills. We're actually taking a trip to Blackfeet at the end of, the first week of May, to finish up some wills up at Blackfeet. And interestingly enough, that's where we get the most requests for wills. But there are not people in the private bar. I guess, and I don't know a lot of folks in the private bar because I primarily stick to tribal court, where there are not very many people, lawyers in the private bar practicing. There are tribal advocates. That's my crew. That's who I hang with. But there's probably a handful of lawyers in Cut Bank that could go over to Browning and do wills. I don't know how much they would charge, but...
I wonder too if maybe under pro bono, and I don't know if the state bar is getting many requests where they can refer out. Might be another avenue.
I mean, part of,
Let these guys
Yeah,
know
if you
they'll.
guys, we can't recommend anybody, we can give lists out, and we meet with people all the time, and that's one of the problems we have. So when we know that there's a place that they can go, we just refer them there. So if you want to be on that, and a lot of it is pro bono.
Well,
I mean,
all
we
of it I
can
did
do
was pro bono.
a list and send it out and provide it to our beneficiaries. It's just, we don't usually have a list of people that are upset because they're not getting calls. I mean, we love it when
Yeah,
people tell us
yeah.
that.
They ask, they do
ask.
ask where they can get a will, but we don't. We
So
just
what we
refer
do-
to.
To Joe or the
Joe,
Montana
yeah.
AAA, but if you want to put your name on a list, I mean, the more the merrier, and we'll just hand that list out, because we can't recommend, but we can refer them to the people that we know.
right, and we have to be very careful about that too, about who we refer and list. But yeah, that is fantastic. My perspective over doing this for 10 years now, and like I said at the beginning of my presentation, we wanted this to be a sustainable effort and to train as many folks in the private bar to meet this need. And we would target small towns close to reservations in the state and I would train lawyers so that they would do these. But we aren't seeing it happening. And I think part of the reason is folks in the private bar are there to make money. And there may not be a whole lot of money, essentially, in this business of doing wills. That's all I can think of. But that's all the more reason why we need to keep doing these every year and get more and more people trained. So thank you for everyone that attended, and I hope you feel a little more comfortable taking on some of these wills and take them on. And if you have any questions, call me and I will happily talk to you and not charge you anything for the consultation.